Okay, thank you for joining us, everyone. We'll give it about another 30 seconds while everyone loads in before we get started.
You guys have a Twitter account?
Yeah.
Yeah?
Let me search you up. What do you like with my phone?
No, I'll, if you guys are going to tweet it, I'll tweet it, and probably fee out my organization will retweet it. So I'll take a picture of it.
Okay, Luke, we might be able to get something working on that, but I think for the moment we're sending the link out through a couple of other means at the moment.
Might put the socials in the chat for everyone to see.
Okay, and with that, we also might get started. So thank you everyone for joining us. We've got a number of panelists here tonight. Of course, we have Professor Stephen Smith and Dr. Melanie O'Brien, who are both professors of international law here at the University of Western Australia. We have Mr. Eoin McNamara and Mr. Alessandro Silvestri, who are both working on their PhDs, with Mr. Eoin McNamara being with the Finnish Institute of International Affairs, working on his PhD in NATO studies, and Mr. Alessandro Silvestri working here at the University of Western Australia, focusing on overarching legality of international humanitarian law. And of course, we also have a committee member of the ILS, Caroline Sabater, who is working on the double masters of international relations and international law along with myself. Thank you everyone for joining us tonight. We'll go straight into the questions to try and keep things running, because we have a number of questions to get through in a very short amount of time to ask them all. At about 45 minutes past, we'll be starting to open the questions up to the audience to see if anyone has any questions I'd like to ask. So we'll start first with you, Dr. O'Brien, or Melanie, as I'll go from here on. Ukraine has filed a claim before the International Court of Justice alleging that Russia has breached the Genocide Convention. How do you see this case proceeding before the ICJ?
This is a really interesting case that's gone ahead and obviously happened very quickly because the conflict only started a few weeks ago. But what happened was that Ukraine filed a case alleging that Russia has violated the Genocide Convention, which on face value may sound quite strange, but Russia has given the reason or justification for its invasion of Ukraine as being that it is trying to stop genocide from happening in the Donbass region. So that's its justification for the invasion. So on that principle, Ukraine has argued that this is a violation of the Genocide Convention because it's a misuse of the term genocide, and it's they're arguing that they are being subject to a violation of their rights under the convention because Russia is conducting a military operation in Ukraine on the false basis of saying that a genocide is being committed. And there is absolutely no evidence that a genocide is being committed in Ukraine. So it's a really interesting argument, and it's quite unusual because usually what we see when there's a case brought to the International Court of Justice under the Genocide Convention is that it is about someone actually committing genocide and breaching the convention in that way. So this is really, really different. So where we're at now with the case is that it has moved quite quickly, obviously because of the very specific and serious crisis that is going on in Ukraine. So what happened was Ukraine requested what we call preliminary measures. So this is a request for the court long before we get to the merits stage of the argument. And this request is where a country can say, look, in the meantime, before you start thinking about the merits, can you please order the other country to do something in particular? And basically Ukraine's request was to ask the court to tell Russia to stop its military action in Ukraine. And in fact, that's what the court did. So it was quite a quick turnaround. They had oral hearings and Russia did not show up to that, which was quite interesting. But so there was a very full table for Ukraine and a completely empty table for Russia. But the court is still permitted to make rulings even if one of the countries does not show up to the case. So they issued their preliminary measures order and they actually ordered Russia to stop their military operations in Ukraine. And they also ordered anyone, they made sure that covered not only Russian military, but any other and basically any other person that Russia has control of that is involved with that has to stop any activities that are related to that. So in terms of where the case will go from here, so a case in the International Court of Justice is binding on the state parties, so it is a binding ruling on Russia. However, obviously, as we can all see, Russia has not actually complied with that. And it's a bit of a sticking point because the next step for implementing compliance is to go to the UN Security Council. And obviously Russia is a permanent 5 member of the Security Council and would veto any resolution to be passed to enforce the International Court of Justice order. So we're at a little bit of a sticking point, but it's still really important from a legal perspective that the court did that, because it is actually saying, look, just prima facie, we have jurisdiction, but it's also the ICJ is the world court. And so for it to say, actually, Russia, you need to stop what you're doing in itself is really important. So the next stage will probably not be for a little while, but it will be the preliminary objection stage, which then is where the two countries will argue about whether or not the court has jurisdiction before we even get to the merit stage. That's where we're at with that one.
Wonderfully expositional. Thank you so much, Melanie. Did anyone else want to have anything to add on to that question? Okay, no worries. So we'll move on to Professor Smith or Stephen. Given Russia's role as a globally engaged state and prominent international actor, how do you see this conflict impacting their ability to engage in international legal institutions going forward?
Well, it won't necessarily stop Russia from engaging in international legal institutions. So, for example, Russia is obviously a fully fledged member of the United Nations. It's a permanent member of the Security Council. It's acceded to the jurisdiction of the International Court of Justice. And so in terms of its exclusion from international institutions, it almost certainly won't be excluding itself. So I fully expect that Russia will continue. Of course, as Mel has made the point in her very good exposition of how the issue of genocide came to be a focus of this military conflict, and the general proposition in terms of international law and use of force. From a diplomatic or a political or a perception perspective, from Russia's perspective, it was easier for them not to turn up to the ICJ than to suffer the humiliation of having all of their arguments rejected. So if you stand back and just look at general public international law so far as the use of force is concerned, clearly Russia's invasion of Ukraine is unlawful, is contrary to Article 2 of the United Nations. There is absolutely no justification in terms of self-defense, so very basic fundamental principles of the UN and international law have been broken in that respect. And as Mel has pointed out, the notion of Ukraine having committed some form of genocide in the so-called separatist states, or the Donbass or Luhansk, there is no basis for that whatsoever. Of course, it's open to international institutions if they have the power within their own constitution or constituent articles to suspend or exclude individual countries who have fallen into disfavour. And in a different context, for example, you would have seen that the International Football Association has excluded Russia from its deliberations. It's of course open to the General Assembly to move to suspend a member, but that again really requires the cooperation of the Security Council under Article 5 of the United Nations Charter. And of course, as we've seen so far, one of the difficulties we see with the effective operation of the United Nations is the veto power of the permanent members. It would, and this has occurred in the past in the General Assembly, be potentially open to the General Assembly to refuse to allow a Russian renewed credential to the General Assembly, and that is more symbolic than substantive. But in terms of Russia continuing to engage within international institutions, I expect that it would do so, but choosing its mark carefully, as it did in not turning up to the ICJ preliminary orders hearing. But it's highly unlikely, in my view, that any of the major institutions would seek to exclude Russia from its deliberations. Yes, it's acted outrageously. Yes, what it is doing is contrary to international law in terms of the invasion per se. One area that Mel didn't touch upon, but which she is one of our experts in, of course, is also international humanitarian law, or what we used to call the law of armed conflict or the laws of war. And there are clearly incidents which have occurred there where you can mount a respectable argument that Russia has targeted civilians or civilian objects, which of course is contrary to international humanitarian law. And that may subsequently see measures taken to get individual Russians, either military or political individuals, before the International Criminal Court on breaches of the law of war or breaches of international humanitarian law.
Fantastic. Thank you so much for that, Stephen. That's actually a very good point, and I'll circle back around to you before we move on to the next question, if that's okay, Melanie. The ICC is actually investigating war crimes in the conflicts. Could you explain the parameters and the challenges of this investigation?
Yeah, so this is also quite an interesting situation because Ukraine and of course Russia, neither of them are state parties to the International Criminal Court. But after the invasion of Crimea in 2014, Ukraine actually submitted a declaration to the court and granted them limited jurisdiction in Ukraine. They followed it up with a subsequent declaration enlarging the time period of that. So the Ukraine has allowed the International Criminal Court to have certain jurisdiction over war crimes and crimes against humanity only. And it's a really interesting situation because actually, you ask the question of, well, why is Ukraine not just become a party to the International Criminal Court? That would make it easier. And in fact, initially they couldn't because they had a constitutional provision that meant that it was basically contradictory with their constitution to become a state party. So they took a few years and they amended the constitution, but they still haven't become a state party. And some cynics may say that, well, by submitting a declaration, the court can do its work, but by not being a state party, Ukraine then does not have to pay the fees that a state party would have to do to contribute to funding of the court. So they can make use of the resources without having to actually contribute to them. So what we've got at the moment is the International Criminal Court is investigating, and in fact, the prosecutor has already been to Ukraine himself, and Karim Khan has been there and is conducting an investigation. And thinking about this issue of resources, the court is quite limited for resources to the point where the prosecutor has put out a call for more resources to come in specifically to fund this investigation in Ukraine because of the lack of resources. So what they'll be looking at is violations of international humanitarian law. So they'll be looking at war crimes that fall under the Rome Statute of the International Criminal Court and crimes against humanity. But one of the issues with this, and that I've written about, is that the quantity of war crimes that we find under the Rome Statute are not comprehensive. So they don't actually cover all violations of international humanitarian law. They only cover a few of them. So there are some crimes that are being committed by Russia in Ukraine that the International Criminal Court simply cannot prosecute for. So that's really problematic. There are a number that they certainly can, and Stephen has mentioned attacking civilians. There's also attacking civilian objects. So that includes things like residential buildings, town squares, cultural objects as well. So we've seen a lot of attacking of schools, attacking of hospitals. These are all protected objects, and there has been a lot of that going on. But also what we've been seeing is, as an example of what the ICC can't prosecute, is the use of particular types of weapons, which are prohibited under international humanitarian law, but there is no war crime provision under the Rome Statute to prosecute them. So this includes, for example, the use of cluster munitions, which amount to weapons that have an indiscriminate effect. Because a cluster munition, when it explodes, it releases a whole lot of submunitions, and so it can't actually be directed to a particular military target. They've also been using inaccurate ballistic missiles as well. So these are weapons that are described as indiscriminate, and it is prohibited to use those under international humanitarian law. But the ICC is not actually able to prosecute anyone for that particular war crime. So this is quite serious, that this gap that the ICC has. So it's really great that they're there, and it's really important that they're there and they're on the ground already and they're gathering evidence, which is really important. And any prosecutions they do will be quite significant. But at the same time, we also need to recognise that it does have certain limitations to what it can actually prosecute people for.
Of course. Well, you've mentioned civilians within the conflict quite a number of times now, and this seems like a perfect segue into Alessandro's specialty, actually. So Ukraine has utilized its civilians as well as international volunteer groups to defend its territory in the conflict. How does this intersect with human rights law regarding combatants and the protections for civilians?
Yes, that actually ties very well into my research, because my whole PhD is on civilians participating in warfare. And I guess I'm going to be tying into what Melanie and Stephen have said, and just explain a bit of the theory that applies in situation of armed conflict. Because a lot of times we hear the words international human rights law and then international humanitarian law, but we use them interchangeably, but there's actually a mistake there, because they mean different legal frameworks. So in general, in situations of peace, we have the so-called international human rights law. So for instance, do not go out and kill someone, just the easy provisions that I guess we're accustomed to here in Australia. But then there is such a thing called lex specialis, which means a special body of law that applies in situation of armed conflict. And that specific body of law is called international humanitarian law. And it's what Stephen was referring to when he was talking. So international humanitarian law applies in situation of armed conflict. Now, there are so many differences between international humanitarian law and international human rights law. And the most important one, which is possibly the most fundamental principle of international humanitarian law, is the so-called principle of distinction. Under the principle of distinction, you must at all times distinguish between a civilian and a combatant. And you can only target, which is the legal jargon for killing, combatants. Now, the body of law where you can find all of this, possibly the Geneva Conventions, the additional protocols, and customary international humanitarian law. But the question then becomes, what happens if a civilian is shooting, I don't know, Russian officer? How does that work? How does the law view these kind of situations? Well, there are a couple of exceptions. A couple of exceptions where you can actually target a civilian. Now, the first one, which is the one of my PhD, is the so-called direct participation in hostilities. That means that when a civilian is, as I said, directly participating in hostilities, that civilian can be killed. Now, what does it mean to participate directly in hostilities? Because if we say participate directly, that means there is a line between direct and indirect. What actions constitute a direct participation? Now, obviously, if I take a shotgun and I shoot, there is very likely direct participation in hostilities. I don't really think there's going to be much to discuss on that. But what happens if I'm driving an ammunition truck going towards, I don't know, the battlefront? Is that direct participation in hostilities, or is that indirect? So the line between direct and indirect is very much in contention in academia. And we are trying to get some sort of agreement on this difference between direct and indirect, especially now that civilians are such a big part of warfare. Back in the day, imagine like this isolated battlefield with two armies going at each other. But right now, if we imagine warfare, we imagine, I don't know, Aleppo, like an urbanized center with so many attacks happening over years and years with no clear winner. And so civilians become very important. Also with the sophistication of warfare, we need civilian contractors to operate some of the machinery, because some weapons that we use or some of the equipment is highly sophisticated. And that's, so obviously understanding if civilians are participating directly in hostilities is the first question that we need to ask ourselves when it comes to international humanitarian law. And the second idea that we can, I guess, discuss is the principle of proportionality. Now, The principle of proportionality is based on the idea of collateral damage, which I'm sure you've all heard before in your, in your lives, like, oh, that's just collateral damage. So in legal jargon, the collateral damage is the idea that you can authorize and accept civilian casualties if the military gain resulting from that operation outweighs such loss. So let me give you an example. Well, there is no right or wrong answer, but I'm trying to get you in the mindset of what happens. If you have in one room, such an important figure in the military operations of Ukraine, for instance, and you have a civilian, the Russians should ask themselves that question: is targeting such person, such military chief, outweighing the potential loss of the one civilian who's in the same room of this military chief? Now, the question, unfortunately, has many facets, which we are not here to discuss, but that's the idea of proportionality. So is the civilian casualty proportional to the military gain that you're gaining? Now, so many of the examples that we are getting nowadays seem to be pointing towards a different answer, which is they were not proportional. And they were being, civilians were allegedly targeted, rather than just being either directly participating or collateral damage, which is quite concerning and obviously not a great look for what Russia is doing in the international stage right now. And very importantly, if you are a civilian, you do not get, and you're directly participating in hostilities, you don't get so many of the privileges that are afforded to combatants. For instance, you must have heard prisoners of war before, which I'm going to refer to as POWs. POWs have a lot of privileges because the moment they surrender or they are not fighting, they can be captured, and they have privileges that are usually contained in the Third Geneva Convention. However, this line is nowhere near as clear for civilians, because if we have a distinction between a combatant and a civilian, and we create all this right for the combatants, then what happens if a civilian is directly participating in hostilities? Does that person get POW status? And there are so many people in academia that actually argue they should not. And that becomes quite an interesting question when it comes to the targeting of civilians who are directly participating in hostilities. So what happens to them? It's a gray area. It's a big gray area. And in my personal thought, we should create some sort of a consistency and a rule that everyone should adhere to. Otherwise, that gray area is going to cost so many lives that should not be lost just like that.
Some very heavy-hitting stuff.
Mm.
We'll try and move on to something slightly lighter and go to our man in the field. So, Eoin, as a highly relevant institution at the moment, what has NATO done since the conflict has begun? What actions have they taken in this instance?
I don't think this is going to be any lighter, unfortunately. We're talking. So I suppose I'll start by personalizing it slightly in a nice way. That I know, Rafe, and thank you for the invitation. It's great to be here virtually at the University of Western Australia this evening. I know Rafe because in my early PhD days, funding wasn't great, so I also moonlighted as a high school teacher in Estonia on the International Baccalaureate program, and Rafe was one of our international students. So it's always great to see where students go and where they get to, and see them doing well. So I saw another one of my students from around the same time. She was a master's student like you guys now, and she's gone out into the world. She worked for, I think she's Ukrainian, at the University of Tartu. Very strong links with Eastern Partnership countries, particularly Ukraine. So you get a lot of students from that part of the world. So one of my former master's students, she worked for a think tank in Kiev for a bit, and now she works for the German Marshall Fund of the United States, I believe. And I saw a picture of her. I think it was used in the media. She's based in Brussels, outside the European Parliament, kind of trying to lobby or beg, essentially, desperately, MEPs to do something. And one of those areas that the Ukrainians are constantly calling for from NATO, in particular, is the implementation of a no-fly zone that would essentially strip Russia of its air power advantage, which is an advantage that it hasn't fully utilized as yet, and the Ukrainian Air Force have done very, very well to stay in the game. Whether this can be maintained over the long term is hard to know. So this call, and President Zelensky has made this call a number of times for NATO to get involved through a no-fly zone. The problem with that is all no-fly zones to a T need to be enforced militarily, which would mean most likely, incredibly likely, that NATO aircraft would have to target Russian aircraft in the air, and NATO aircraft would have to target Russian air defense systems, which are located on the ground, some of which on Russian territory, most likely. So if you can imagine that no-fly zone proposal runs into difficulty very, very quickly, because it brings us it will likely bring us very, very quickly up the chain of escalation should Russia retaliate. And of course, NATO has 3 nuclear powers within its ranks and has an integrated nuclear posture, and Russia is a nuclear weapons power as well. So the stakes are extremely, extremely high, and so NATO has cautiously shied away from that. Nevertheless, NATO has not yet got involved institutionally directly, but a number of NATO states have. And what we're seeing now, I've been having some good conversations with some good investigative journalists who follow those things and have their ear to the ground. Weapons are absolutely flooding in from Europe into Ukraine. And these have had a significant impact on keeping the Ukrainian resistance going, particularly anti-tank weapons. The Javelin anti-tank missile, the NLAW anti-tank missile supplied by the United Kingdom. The Javelin is American manufactured. Germany has reversed its course. It is now, had a St. Paul-like conversion, and 2 weeks ago, and is now sending lethal aid to Ukraine, and this is keeping the Ukrainian resistance in the game. These anti-tank weapons have devastated the Russian front line. The Russian logistics are in disarray. The Ukrainians have Turkey is still a NATO member, have Turkish manufactured drones that can kind of get behind the enemy lines and target Russian logistics as they slow down. And of course, it's the old phrase in our English-speaking militaries that amateurs talk tactics and professionals talk logistics. And if your logistics are in disarray, as the Russian logistics are, your battlefield progress is going to be slow. So these weapons coming in from different European states and from the United States have had a significant impact in by stealth, or not necessarily by stealth, indirectly keeping the Ukrainian resistance going to a level that has surprised many in this asymmetric conflict. Nevertheless, what we're facing on, and this there should be a lot of material for. I'm not an international lawyer. I come from strategic studies. I do mostly military strategy in my research and my publications. But what we're looking at now, and the word out of NATO just this morning, my time, this afternoon, late evening, your time in Perth, is that what has been leaked to journalists is that what we're looking at now militarily in Ukraine is a bloody stalemate. So lots of atrocities are likely to be committed, lots of war crimes. Russian infantry, like its logistics, in disarray. Some have said that, you know, most of the world is on the side of Ukraine, that this is a good thing. Russia's lost its agility to capture major cities, but Russia might not have very solid or steady infantry right now, but Russia has weapons, very destructive weapons, and has changed its battle plan from agility to take cities quickly at lightning pace to digging in, targeting civilians, trying to make the whole situation so unbearable that the Ukrainians will surrender on the terms that Russia would prefer. That is the Russian strategy right now, which is very, very attritional and from a humanitarian perspective, and in my view, horrific. So that's where we are in Ukraine. That's where we are with NATO's reading on Ukraine. We will, of course, in NATO, have to rethink deterrence for the NATO territories that border Russia, Belarus, and Ukraine. Previously, leading up to now, the logic has been on tripwire deterrence, not to create a big military buildup with very heavy military infrastructure on that border. Instead, have a light military presence, US troops, Canadian troops, German troops, French troops, British troops, all contributing to it, but with battle groups, say in the Baltic states, numbering multinational battle groups, numbering no little more than 1,000 soldiers. So this was the signal to Russia that if you encroach on Baltic or Polish territory, then you're triggering a much bigger international conflict that is undesirable for you. So now you are deterred. As my last point on this, I will simply say I'm not so sure that's good enough to deter Russia anymore from a wider conflict between Russia and NATO. If things escalate further from Ukraine,
okay,
maybe so NATO needs to NATO needs to rethink its deterrence posture for its eastern flank. We're probably heading for a heavier deterrence posture. So I'll leave it there for now. Thanks, Ray.
Yeah, no worries. Well, we definitely have some more questions coming up on that, but you brought up another question that's been asked both by our audience and the question that we have for Stephen at the moment, actually, regarding weapons being brought into Ukraine. So I was going to ask Caroline a question, but I'll quickly jump back to that one before we go back to you, Caroline, just because it's topical at the moment. Australia has pledged around $70 million in lethal military assistance, as well as humanitarian assistance to Ukraine. What are the legal ramifications for sending weaponry to a foreign state engaged in conflict? Would you mind answering that one, Stephen?
Yeah, well, Ewan's dealt with it, if you like, from a strategic or a military or a defence perspective, but it's actually historically a very interesting area of public international law. And so when we, decades ago or centuries ago, you would examine this issue as an aspect of international law, the starting point was essentially a thesis or a doctrine called the principle of neutrality. In other words, if there was a conflict between two nation states, then other nation states could not intervene. And this particularly applied, if you like, in the modern era and came into question and was tested where you had a conflict within an individual nation state where there was an attempt at independence, so where you had essentially a civil war. And so in the case of Russia and the Ukraine, it's of course a pertinent and relevant international legal question for Australia, because we are contributing not just humanitarian assistance, but also military assistance or lethal assistance, as it's called. And so the question is, does this in any way breach public international law? Does this in any way breach the old principle of neutrality? Or is it justified or justifiable under international law? My own view is that the old sort of doctrine or position of neutrality doesn't meet the current circumstance. And I think that the ultimate argument, legal argument for Australia and other countries, in particular NATO countries, providing Ukraine with lethal force is essentially one of Ukraine is acting under international law and the UN Charter, exercising its rights of self-defence. And this is simply assisting Ukraine to exercise its inalienable right for self-defence. Now, one of the principles of this area of law is you've got to be very careful not to become a combatant or a member of the conflict itself. And so if, for example, Australia were to send troops on the ground, hand over on the ground, the rocket launchers and the like, and become part of the contest, then that would be Australia introducing itself as one of the combatants or one of the contestants in the conflict. And so NATO countries have been very careful not to do that for the obvious, not just legal, but for the obvious strategic reasons that Eoin went to, which is NATO is very careful about seeing this conflict escalate, not just because Russia is a nuclear power, but even a conventional conflict between NATO and Russia would very much be a catastrophe in terms of plunging Europe into a broadly based military crisis. So my own view is that Australia and other countries have been very careful to conduct themselves in accordance with international law as they provide lethal force. No one has stepped over the line of becoming a contestant or a combatant per se. And I think the old notion of neutrality, when you look at it through the modern era, when you look at it through the United Nations Charter, there's a very firm ability there for NATO members and Australia and other countries to be saying we're simply acting in pursuance and in assistance of Ukraine's inalienable right to self-defense.
Fantastic. Thank you so much, Stephen. If no one has anything to add on to that, then we'll jump to Caroline. So at the moment, strong concerns have risen around global food supplies and Ukraine and Russia's role in production goods of such as wheat. What is the legality and responsibility of states to protect against food shortages caused by sanctions of these kinds? Sorry, are you there, Caroline?
Yeah, of course. So, yeah, sorry, I missed half.
No, that's okay.
But I've got it here.
I can start again. So there's some concerns at the moment around global food supplies caused by the conflict in Ukraine and sanctions placed on Russia. And my question was asking, are there any kind of legal obligations for states to protect against food shortages of this kind within international law?
Yeah, of course. So one of the major principles of international humanitarian law is to prevent further harm to civilians and civilian objects. However, with food supplies being affected, this includes import, export, but also fields being destroyed by tanks, artillery fire, etc. There's, under the Rome Statute, there is a provision in place for to not intentionally starve civilians. This would constitute a war crime. However, how could we consider Russia invading and causing these food supply shortages as intentional? That could be a question. So there's definitely legal precedent for states to keep food supply at a high and not to prevent any further damage to the people, especially the civilians.
Fantastic. Thank you so much, Caroline. I mean, and going on from there, since we've talked about the humanitarian aspects of this question, I think it's good to actually bring this back around to you, Alessandro. So approximately 675,000 refugees have left Ukraine since the beginning of the conflict. Ukraine has since banned men aged between 18 and 60 from leaving the state so that they may be conscripted. Could Ukraine actually be in breach of international law by not allowing its state's freedom of movement in this instance?
That is actually a fascinating question. Sorry, I was actually typing a question for Stephen, but I'll see it later. I don't know if we're allowed to ask each other questions, but actually I had a question for Stephen.
100% you can, yeah.
Actually, I'll say it now and then I'll finish the question, because Stephen, you were minister in 2008 when Russia attacked Georgia for the 5-day armed conflict. What was the vibe in those rooms with the Russian officials? What were their perspectives? Because I guess that was the first time they actually engaged in an armed conflict in their idea to secure that kind of border. So I just want to know what was the atmosphere in those high rooms when it comes to Russian officials. But anyway, I'll answer your question because it's actually quite fascinating. The idea that right now, fighting for the military or being enrolled has changed a lot in the last few years. You know, back in the day, it seemed like one of those inevitables that we all had to do it. But now the outlook has actually changed. Now, obviously, again, I want to stress out the difference between human rights and humanitarian law, and humanitarian law applies in situations of armed conflict. However, and this is something I actually forgot to say before, there has to be a complementarity where human rights and humanitarian law have to work together, and we need to find the boundaries, a workable boundary where we can protect both of them and actually make sure that everything happens according to the law. Now, the International Covenant on Civil and Political Rights is possibly one of the major pillars of human rights at the international level. Article 18, which might not actually seem like the one that applies to this situation, but the whole conversation was actually started under Article 18. It says, and I'm reading because I had to write it down, that everyone will have the freedom of thought, conscience, and religion, and no one shall be subject to coercion which would impair his freedom to have or adapt a religion or belief of his choice. Now, while it would not seem that this has anything to do with the possibility to retain someone for service, the Human Rights Committee actually got together to have an addendum, which are general comments that have been approved on top of the ICCPR. And it actually says that there are consensus objections to military service that can be based on personal beliefs such as religion and morality. So basically, and I'm reading from that general comment, that in so much as the obligation to use lethal force may seriously conflict with the freedom of conscience and the right to manifest one's religion of belief. And the truth is, and I wrote something else here down, but it basically says that it is accepted under Article 18 that one person can oppose to being forced to fight under personal beliefs and morality, in particular religion, but the comment actually doesn't specify anything about religion, if not just at the end. So technically you could say that Ukraine cannot do what, cannot get men to stay and fight. However, there are some exceptions in the name of public safety or greater threat to the nation. Now, this is another situation where it can get a bit tricky because under Article 4, in time of public emergency, there can be derogations to some of the rights included in the ICCPR. But it says that no derogations can be made under some articles. And one of these articles is actually 18. So you would think that since there are no derogations can be made around Article 18, then it's kind of like chessmates. So Ukraine cannot be doing what it's doing. However, then you go and read under Article 18, and it says, and I wrote it down, that that you can actually change some of its provisions based on safety, order, health, or morals, or the fundamental rights and freedoms of others. So that means that while on Article 4, you cannot have any derogations for anything that threatens the safety of the state, at the same time, there are other derogations that can be made under Article 18 based on safety, order, health, or morals of the fundamental rights. So then again, it's quite tricky because it depends on how you want to shape the narrative on this question. However, I believe that under Article 18, it would be quite hard to argue that it wasn't in the interest of safety, order, health, or morals, or the fundamental rights and freedoms of others that Ukraine actually asked men to stay and fight.
Okay, wonderful. Thank you so much for that, Alessandro. We have time for probably one more question, and I would like to direct this one to you, Melanie, just because I think it's a very interesting one for international law, just before we go to the audience questions. And then, of course, Stephen, if you wanted to respond to Alessandro's question after that. But sorry, Melanie, so President Putin has committed actions that very conceivably constitute crimes of aggression. Could this be the first charge of a crime of aggression under the ICC statute leveled against a modern figure?
Very short answer, no. Because the ICC, the crime of aggression under the Rome Statute only applies in very specific circumstances, so it won't apply here because Russia is not a state party and Ukraine is not a state party. The crime of aggression has to actually, both countries have to be a state party and to have ratified the amendment that is the crime of aggression under the Rome Statute. So the very short answer is no.
Okay, thank you so much. With that, we'll move to the audience questions because we have a few of those. But Stephen, did you want to respond to Alessandro's question, sort of asking what the atmosphere was like during the Georgia negotiation or invasion by Russia? Sorry.
Well, you had Abkhazia and South Ossetia are essentially claimed by Russia, 2008, 2009. Australian officials never actually sat down with Russian officials, and it enables me to make a relevant point, which is Australia and Russia have never had a deeply ingrained relationship. And so we have next to no political relationship, next to no economic relationship. And generally during the Cold War and in the current era, it's very easy for Australia to apply sanctions to Russia or the Soviet Union because we have next to no relationship with them. And so that, for example, is qualitatively different with China, where we have a highly focused trade relationship with China. So during Georgia and Russia, South Ossetia and Abkhazia, the thing which interested Australian officials most was that we saw for the first time cybersecurity being used as an attack weapon in essentially a traditional kinetic conflict. And so power stations, infrastructure, a whole range of Georgia's critical infrastructure was brought down by Russian cyber attacks. And this really started to focus Australia and other countries on modern warfare, not just being kinetic, but also sort of a grey zone of cybersecurity. And that's why now, literally as we speak, we've seen legislation go through the Australian Parliament, which is aimed at protecting critical infrastructure. And so whilst Australia, and I was Foreign Minister at the time, we sided with all of the obvious supportive General Assembly resolutions about Russia acting contrary to international law, Georgia's territorial sovereignty being unlawfully disturbed, etc. We weren't in the front line and we weren't even in the back stalls because of the geography and the history, which effectively separates Australia from any deep-seated, meaningful relationship with Russia. But the cybersecurity aspect did interest us, and that, to use that classic phrase, started to make us alert, but not at that point in time alarmed.
Fantastic. Thank you so much, Stephen. We have a couple of questions from the audience, and we'll try and get through as many as we can. We're going to start with this one asking about Belarus, and this is open to everyone to answer, so feel free to chime in, first come, first serve. As Belarus is enabling but not actively participating in Russia's actions, would they likely face consequences from the ICJ or more broadly international law?
I can take that for a bit at least. There has been discussion about this amongst international lawyers about whether essentially Belarus is culpable in this situation because they are actually allowing Russia to fire rockets from Belarusian territory into Ukraine. So they are a participant. And of course, we know that Belarus is led by a dictator and who is, very close with Putin. So definitely there is room there for Belarus to be held accountable or face some kind of consequences somewhere. Obviously it's probably not going to be the Security Council, but yeah, there is the potential for them to be brought into, I would say less likely personal like individual responsibility, but more state responsibility through, for example, the ICJ. Yes.
Fantastic. Thank you so much, Melanie.
If I can just add another layer to that from my discipline in international relations, political science, strategic studies, that also that Belarus and its assistance is likely to increase as well. We had a constitutional referendum in Belarus a couple of weeks ago where they erased their non-nuclear status, which some see as an indication that they might be paving the way for hosting Russian nuclear weapons on their territory. Furthermore, as the war becomes ever more and more attritional, more and more pressure will build on Alexander Lukashenko to send combat troops into Ukraine to kind of help the Russians out. And let's not forget, after the staunch protests against his rule in 2020, he is being completely propped up by Vladimir Putin at this stage in terms of financing and loans that are keeping his regime going. So sometimes with Lukashenko, he's historically tried to resist Putin's onslaughts, but at the moment, it's a matter of if Vladimir Putin says jump, Alexander Lukashenko is likely to say how high. So that's an excellent question on Belarus, and I would say keep watching Belarus. It will have more of a role, not less, to play on this as things move forward.
Rafe, just very quickly, I absolutely agree with Mel, and I think procedurally the way in which the Ukraine could get Belarus before the ICJ is to seek to join Belarus to the action which it has on foot, where provisional measures have already been ordered by the ICJ, which Mel, correctly and exhaustively detailed at the beginning of our session. So, yeah, I think Mel's absolutely right. I think there is a dispute between Ukraine and Belarus, which could be brought before the ICJ.
Fantastic. This seems to have been a very hot topic conversation. So thank you very much for the question from the audience. As part of that as well, before we start to wrap things up, we've mentioned a few times about the UN Security Council being a vital point of this conversation, but it also being something that doesn't seem to be an avenue which can be taken to resolve it, of course, because of the veto. One of our questions is actually asked, why has the UN Security Council failed to prevent Russia and stop their invasion? I'd like to expand that a little bit more as well, because I think we understand that the veto was the main issue within this context. Do we think then that this could increase calls for reform on the UN Security Council, or do you think this will be something that will just be struck to the side? And that's an open-ended question to everyone, of course.
I can take some of it.
Sure.
Obviously, you answered part of the question, and the veto power and the P5s have always been the biggest issue with the workings of the Security Council. However, I've also heard a few years ago a counter argument, which I actually thought it was quite interesting, because there was a bit of an analysis of why the League of Nations failed. And the idea is so many countries left because obviously they didn't have much of a chance to have their final say. So these arguments, I can't even remember who told me that, but this person told me, what if the Security Council in the veto power is actually the reason why we still have an international institution that is capable of keeping everyone in the same room? If we remember, just before the Third World War, everyone, all the countries ended up, like Germany, Italy, left the League of Nations just before they started their attack. So the idea is, would it be, if we were to imagine a future without the veto power and the P5s, or maybe we can imagine without the P5s, but some countries with the veto power, can we have a sustainable I was just reading Melanie's link in the chat. So can we have a sustainable international institutions that can actually bridge a bit of the realist idea that all countries are out there by themselves and they're protecting their own personal rights, with the idea of having personal interests? That's better put. Or would it be better to have, at the same time, a little bit of international room where everyone can get together and try to find some diplomatic solutions? I'm not saying that the Security Council is perfect, because it is not. However, sometimes it has proven to be effective. And to be fair, I would rather live in a world that has a Security Council than in a world that doesn't. And while we do need improvements, it is also very important to understand that the veto power might actually be the reason why countries have an interest in staying together. And at the same time, however, in a situation like this, having Russia with the veto power would actually ban any sort of conversation from even entering the room, because you know very well that the moment they're going to start pointing the finger at Russia, Russia is just going to veto it.
Very true.
So I think the essential issue with the Security Council and the UN is, of course, the Security Council doesn't represent the modern era. It doesn't represent sort of the community of nations and the multipolar world that we now see. And so Australia has for a long time argued we need to reform the UN, we need to reform the Security Council. And we've argued, for example, that Japan should be a permanent member of the Security Council. India should be a permanent member of the Security Council. And in due course, you could also mount the same respectable argument for Indonesia, as Indonesia grows from a global, from a regional ASEAN influence to a global influence. Of course, the only institution that can reform the Security Council is the Security Council itself. And as you'd expect, the veto powers are very wary about giving away the veto power. But I think the single biggest failing of the United Nations, because despite the veto power, despite the Security Council, the single biggest failing of the Security Council and the UN is that because of that veto power, the United Nations over a long period of time has been unable to engage in effective peacekeeping and enforcement actions. And so in the Balkans back in the 90s, you see the UN hamstrung, and eventually NATO went in as a regional operation far too late to stop a whole range of atrocities from occurring. So it's been the failure of peacekeeping has been good under Chapter 6. It's the enforcement mechanism under Chapter 7, where what was originally envisaged was that countries would contribute to blue helmets that would go in and that would essentially engage in enforcement action. And we haven't seen that, and that's seen either regional organisations taking that off their own initiative, for example, NATO and the Balkans, or it's seen the argument in international law that there's a broader principle which transcends the UN Charter and the Security Council called the responsibility to protect, which is an argument that our own Gareth Evans has been prosecuting for a considerable period of time, that in the absence of any international institution moving, community of nations have a responsibility to move, to protect, to prevent genocide, to prevent atrocities, to prevent terrible conflicts from continuing. And that's why you've seen some currency to that principle or argument of international law that we have a responsibility to protect. It's not accepted as a principle of public international law, but it's essentially an argument which has arisen as a result of the failure of the Security Council enforcement actions, which all shoots back to the veto power.
Thank you so much for that answer, Stephen. We've only got a couple of minutes left, so we'll actually go back to one of our first questions from Nadia, who asks what the possible outcomes for international law generally are. And I might actually just expand that and ask if each person could spend 20 or 30 seconds just answering their own area, what they think the outcomes of this situation will be going forwards, whether it be international law, international strategic policy, depending on your area and how you would like to answer it, but just 20 or 30 seconds just to finish off the session. We might start with you, Stephen, since you just finished speaking, if that's okay.
Yeah. Well, I think this is another illustration which shows us that public international law is one thing, but realpolitik and international military capability is another thing. And so often when you read public international law, you'll see references to public international law aspires to how things should be, but the realpolitik of geopolitical contest between countries often overrides that. So, for example, you see not just Georgia and South Ossetia and Abkhazia being a precursor to this. Of course, in 2014, we had the annexation of Crimea, which is unquestionably contrary to international law. But in the end, no one was able to do anything other than to shrug their shoulders and say it is what it is. And so this is where, for those students of public international law, the rubber hits the road on public international law versus realpolitik, and that's been a source of enduring frustration to public international lawyers in perpetuity.
Fantastic. Thank you so much. And we might just quickly move on then to Caroline, if you wanted to sort of give a 20 or 30-second summary of what you think the outcomes of this situation will be for international law.
Yeah, of course. I think similar to Stephen, I think perhaps definitely real geopolitics are probably going to take over with international law. International law tends to work when all states comply, which we haven't really been seeing with Russia. So I think as aggression escalates, perhaps Western powers might be forced to bring things to a more of an international conflict than we're already seeing, unfortunately. Bit of a pessimistic outlook, perhaps.
Thank you so much, Caroline. We are on 6 o'clock now, so I'm very time conscious of that. So if we might just be able to go through the last few answers quickly, if that's okay. Melanie, did you want to go next?
Sure. I think just to focus on the International Criminal Court, I'm sure that we will see individuals brought before the International Criminal Court being prosecuted for war crimes committed in this conflict. We have actually seen in the past couple of weeks that Karim Khan, the prosecutor, has announced that he's requesting 3 arrest warrants for Russians in relation to crimes committed in Georgia. So that's an interesting, perhaps political choice there of moment to announce that. But so we can see that there's clearly something going on, definitely already. So no doubt, but whether or not Putin will be one of them, well, that remains to be seen.
Thank you so much, Melanie. Ewan, did you want to finish up? Sorry, and then of course, Alessandro.
So briefly, from taking a political military perspective on it, a bloody stalemate, getting increasingly bloodier in Ukraine, a real tragedy for Ukraine, not of its making, and something we thought we wouldn't see for a while. Increased questions coming over Vladimir Putin's power as president of the Russian Federation, because he and his generals have made some severe battlefield miscalculations, and they can't sweep that under the rug from the Russian people for too long more. There's only so long propaganda can go in this world. So we'll have to watch this space over the coming weeks and months.
Should make for some interesting reading. And then Alessandro, if you wanted to finish up, thanks.
I'm just building off what Melanie just said. We live in a world that doesn't forget and doesn't want to forget. Back in the day, maybe you could get away with things because we didn't have the same means to capture and remember some of the atrocities that would happen in a battlefield. But right now, those images and those stories are all over the world, and some of them have been confirmed. So the idea is we have proven facts that Russia is abusing so many bodies of law, in particular international humanitarian law and international human rights law. So it would be a great shame, and yet it's a great opportunity for the international community to show that they can actually follow through with its legal provisions and what it stands for. So it's a great opportunity right now to show that international law actually matters in the world.
Fantastic. Thank you so much, Alessandro. I want to thank all of our panelists for coming tonight, as well as our audience. I'm sorry we didn't manage to get to all of your questions, but a very special thank you to Professor Stephen Smith, Dr. Melanie O'Brien, Mr. Eoin McNamara, Mr. Alessandro Silvestri, and Miss Caroline Sabater. Thank you so much for coming tonight, guys. And we look forward to seeing you at our next events. Cheers.
Thanks, Ray. Good day, mate, as they'd say down there.
Thank you, guys. Have a good night. Oh, good day for you, actually, Eoin.
Thanks.